Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Our fellow classmates and respected lecturer Dr. Arif Fahmi, the lecturer of Constitutional Law for this semester. We are the second group from TLB6. Our topic of presentation today will be on the executive power of constitutional monarchy with recent experience in Malaysia. Before we go further under this topic, what does it mean by executive powers? It formulates various socio-economic policies and development plans for the development of the country as a whole. In Malaysia, the executive branch of the government consists of the Prime Minister as the head of the government, followed by various ministers of the cabinet. In the federal government, the executive consists of Conference of Rulers, YDPA, Prime Minister, Cabinet and Public Services. Firstly, what is constitutional monarchy? It is a system of government in which a monarch shares power with a constitutionally organized government. Their powers are limited and subject to the constitution. What then the definition of monarch? Monarch can be defined as the ruler of an absolute monarchy or the head of a state of a constitutional monarchy, while monarchy is a government with a hereditary head of state, whether as a figurehead or as a powerful ruler. Move on to the next part, constitution and constitutional. Constitution is the basic principles and laws of a nation, state or social group that determine the powers and the duties of the government and guarantee certain rights to the people in it. Meanwhile, constitutional in government is defined by the existence of a constitution, which may be a legal instrument or merely a set of fixed norms or principles generally accepted as the fundamental law of the polity that effectively controls the exercise of political power. How about the application in Malaysia? Malaysia is a country that ruled by a king who come to power choicely as constitutional monarchy. The Federal Constitution of Malaysia divides the authority of the Federation into its executive, legislative and judiciary authority. Apart from the cabinets, i.e. ministers, the YDPA also holds the executive power in the country. The Yang di-Pertuan Agong or YDPA is the head of the executive authority. However, he acts on the advice of the Prime Minister who heads the cabinet, only on certain matters. Hence, the Prime Minister is the chief executive and the head of the government. For the next part, which is the role of the YDPA as the head of executive member in Malaysia. So, what is the role of the YDPA? First and foremost, the Yang di-Pertuan Agong is the head of Islam in his home state and in Malacca, Penang, Sabah, Sarawak and the Federal Territories of Kuala Lumpur, Labuan and Putrajaya. Second, under Article 153 of the Federal Constitution, the Yang di-Pertuan Agong must safeguard the special position of the Malays and the natives of Sabah and Sarawak and the legitimate interests of other communities. Third, under Article 41 of the Federal Constitution, the YDPA is the Supreme Commander of the Armed Forces. In the case of Armed Forces Council, Malaysia and another, and Major Fadzil bin Arshad. It was held that as the Supreme Commander of the Armed Forces, His Majesty's role could not have been intended by the framers of our Constitution to be merely symbolic or just a figurehead. Surely, His Majesty is expected to play an effective and meaningful role as the Supreme Commander. Lastly, the most important one, the Yang di-Pertuan Agong is a constitutional monarch. Under the Constitution, he is the supreme head of the Federation. Since the powers of the Yang di-Pertuan Agong come from the Constitution provides that in exercising his functions and roles, the YDPA must generally follow the advice of the Prime Minister or Cabinet. This is the definition of non-discretionary powers of the YDPA as stated under Article 40 of the Federal Constitution. Among the non-discretionary powers of the Yang di-Pertuan Agong include, in appointing judges, the YDPA must act on the advice of the Prime Minister. For the appointment and dismissal of all cabinet ministers, the YDPA must act on the advice of the Prime Minister. And in making a proclamation of emergency, the Yang di-Pertuan Agong must act on the advice of the Cabinet. However, for a few functions and powers, the YDPA does not have to act on the advice of the Prime Minister or Cabinet, but can act on his own discretion. This is what we call as a discretionary power. Among the powers include the appointment of the Prime Minister. However, the Yang di-Pertuan Agong must appoint a member of the Dewan Rakyat who is in his judgment is likely to command the confidence of the majority of the members of the Dewan Rakyat. Second, the withholding of consent to a request to dissolve Parliament. And third, calling a meeting of the Conference of Rulers concerned solely with the privileges, position, honours and dignities of their Royal Highnesses, and any action decided at the meeting.
Assalamualaikum warahmatullahi wabarakatuh. My name is FILZAH HIDAYATI binti ZAINUZZAMREE. My metric number is 1202165. Moving on to the next part, the power of YDPA and Sultan in selecting the executive members. For the first part, the power of YDPA to appoint the Prime Minister. First of all, the power of YDPA in the executive branch can be divided into non-discretionary power and discretionary power. The non-discretionary power is where the YDPA must act in accordance with the advice of the appointed Prime Minister and the Cabinet. Meanwhile, the discretionary power is where the YDPA can act according to his power and need not to act accordance to the advice of Prime Minister or the Cabinet. According to Article 40, Clause 2, Paragraph A, Paragraph B and Paragraph C of the Federal Constitution, the YDPA can exercise his discretionary power in three situations, which are the appointment of the Prime Minister, the dissolution of Dewan Rakyat, and also call for the Conference of Ruler meeting. In accordance with Article 43, Clause 2, Paragraph A of the Federal Constitution, the King may appoint a Prime Minister from among the members of Parliament, a candidate whom he considers command the majority support in the House of Representatives. The appointment of the Prime Minister is an undoubted discretionary function of the YDPA. However, this power is not absolute. The YDPA can only exercise this power when there is a situation of hung Parliament or a loss of majority confidence due to death, defection, disqualification or resignation of members of Parliament. For example, in recent political event past year ago on 21st of February 2020, Tun Mahathir Mohamad submitted his resignation to the Yang di-Pertuan Agong. As the resignation of Tun Mahathir Mohamad is fall under the discretionary power of the YDPA, therefore the YDPA can exercise his power without the advice of the Prime Minister or the Cabinet in appointing the new Prime Minister. The YDPA then followed a constitutional convention and asked Tun Mahathir to continue in an interim capacity till a new appointment was made. After that, the YDPA interviewed all the 222 members of Parliament and party leaders personally. The YDPA also consulted with the Conference of Rulers, and last but not least, the palace announced the YDPA's decision to appoint Tan Sri Muhyiddin as Malaysia's Prime Minister. Moving on to the second part, the power of Sultan in appointing Menteri Besar in state level. The discretionary power of Sultan in appointing the Menteri Besar is structured and limited by the federal and state constitution. That means the power of Sultan in appointing the Menteri Besar is not absolute, as the Sultan has to act within the power given by the federal and state constitution. As mentioned in Section 1, Subsection 2, Paragraph A in its schedule of the Federal Constitution, the Sultan or ruler of a state may act in his discretion to appoint a Menteri Besar. It is true that the appointment of Menteri Besar is a prerogative of the Sultan. However, the ruler or the Sultan is not free to appoint anybody he likes. This is because he must appoint a member of a legislative assembly who in his judgment is likely to command the confidence of the majority of the members of assembly. The Sultan has no power to remove a Menteri Besar no matter how unhappy or displeased he is. However, the Sultan may remove the Menteri Besar in the case of where he is satisfied that via a motion duly tabled before the State Legislative Assembly, the Menteri Besar no longer enjoys the confidence of the majority of the members of the House, or where he is satisfied through sufficient and credible evidence after due inquiry that the Menteri Besar has lost the support of the majority of the members of the State Legislative Assembly. According to Article 4, Clause 2, Paragraph A of the Johor Constitution, the ruler shall first appoint as Menteri Besar to preside over the State Executive Council a member of the Legislative Assembly who in his judgment is likely to command the confidence of the majority of the members of the Assembly. It means that when the party which obtains the majority of seats in the general election decides to nominate one of its members of the Assembly for appointment as Menteri Besar, the ruler has no discretion but to appoint him. I think that's all from me. Thank you.
My name is Aina Hazimah binti KAMARUDDIN, metric number 1202158. Proclamation of Emergency. Proclamation of Emergency is an emergency situation concerning the security, economy, and public order. This is accordance to the Article 150, Clause 1 of Federal Constitution. In the provision, it is stated that if YDPA is satisfied that a grave emergency exists whereby the security or the economic life or any public order in the federation or any part thereof is threatened, he may issue a proclamation of emergency, making therein a declaration to that effect. In this provision, it is clearly stated that only Yang di-Pertuan Agong can declare the proclamation of emergency if His Majesty believes that the entire federation is threatened in terms of security, economy, and public order. However, the Yang di-Pertuan Agong must act in accordance to the Prime Minister's advice where it falls under the Article 40 of the Federal Constitution. According to the argument, the Yang di-Pertuan Agong has no choice but to accept the advice because of Article 40 Clause 1 and Article 40 Clause 1A. Any decision made by the Yang di-Pertuan Agong to declare an emergency against his Prime Minister's advice will be a rare and unprecedented act, contrary to the constitutional monarchy traditions. Furthermore, the emergency itself is not a law. Instead, it gives the Yang di-Pertuan Agong plenary legislative power, which is traditionally reserved for the Parliament and the state legislative assemblies. On January 12, 2021, Yang di-Pertuan Agong proclaimed an emergency as a preventive action to limit the increasing COVID-19 pandemic in Malaysia. It will be enforced until August 1, 2021, i.e. the Emergency Essential Powers Ordinance 2031 was gazetted on 14 January 2031 and it will be terminated if the situation is coming back to the normal and if the Yang di-Pertuan Agong revoke the emergency. During this time, the executive has the primary lawmaking. However, under Article 150 Clause 2 of Federal Constitution, the Yang di-Pertuan Agong may promulgate the ordinances without having go through such procedures and as well as the parliament power. The ordinance itself is an extra parliamentary measure and requires no procedures and no votes in parliament. Agong's power to promulgate can be exercised under two conditions, which are there is proclamation of emergency and two houses must not be in session concurrently. The Ordinance 2021 shall have the same force and effect as an Act of Parliament until it is revoked or annulled by both Houses of Parliament or until it lapses at the expiration of 6 months beginning with the date of cessation of the proclamation of emergency. Under Article 150, Clause 3 of Federal Constitution, ordinance promulgated by Yang di-Pertuan Agong shall be laid down before both houses. After Parliament is convened, the ordinance promulgated by the Yang di-Pertuan Agong must be tabled before both houses and will continue in force if both houses approve or will ceases to have effect if it is revoked or annulled by the Parliament. During the emergency, the executive has extended their power in which falls under Article 150 Clause 4. The executive authority of the Federation extends to any matter within the legislative authority of the state. Under Article 150 Clause 4, the government can give directions to the states or any of its officers. The constitutional separation between federal and state executive can be ignored. According to the Article 150 Clause 3 of Federal Constitution, it provides two situations where a proclamation of emergency can cease to exist, which are, First, if it is revoked by the Yang di-Pertuan Agong, and second, if both houses of parliament annul it by resolutions. However, Malaysia's de facto law minister Taqiyuddin Hassan revealed on 26 July that the proclamation of emergency has been revoked as of 21st July 2021. It is actually to come an end on 1st August 2021. According to the Article 150 Clause 7, after the emergency has been revoked, ordinances made for emergency purposes shall cease to have effect after the expiration of 6 months after the date of the proclamation of emergency ceases to be enforced. This means that the ordinance can take effect again until the expiration of 6 months from the date of emergency ends. These are the chronologies of revocation and emergency. 25th October 2020, Yang di-Pertuan Agong rejected the proposal of emergency made by Prime Minister and asked politicians to focus on people's issue and stop playing politically. On 16 December 2020, Yang di-Pertuan Agong accepted the request to impose an emergency in Bugaya and Gerik to prevent the virus from spreading. On 12 January 2031, Yang di-Pertuan Agong declared the emergency to the whole federation from January to 1st August 2031. On 21st July 2031, the emergency has been revoked. On 2020 and 22nd July 2021, Attorney General's Office drafted the Emergency Ordinance Revocation 2031. On 23rd July 2031, Prime Minister submitted a letter to the Yang di-Pertuan Agong to inform about the Cabinet's advice to the King and requested the King's consent. On 31st July 2031, Yang di-Pertuan Agong instructed the Minister in the Prime Minister Department Parliament and Law, Datuk Seri Taqiyuddin Hassan, and the Attorney General Tan Sri Ido Harun to meet him. On 26 July 2031, the question about the status of the King's consent over the decision is raised in Dewan Rakyat. 37 July 2031, the Prime Minister and the Attorney General requested to meet the King to provide further explanation. On 39 July 2031, Yang di-Pertuan Agong expressed his disappointment for what has happened. Yang di-Pertuan Agong has said that he ordered the Honourable Datuk Seri Taqiyuddin to discuss on the revocation of the emergency in the Parliament. Hence, another story happened. However, there is some legal opinion from our former top judge. On 13 July 2031, former top judge said that Gopal Sriram said that Yang di-Pertuan Agong's signature not essential for the revocation of ordinances. Hence, the emergency has come to an end. In conclusion, whatever legal related issue is not slowly handled by the government. The Yang di-Pertuan Agong has the right to know what happened either in or out of the parliament because it is involved the people in this country. The administration of a country should be a balance. Must someone be there to check whether the people of the country receive benefits from the government fairly? Hence, the Yang di-Pertuan Agong should be there to give permission or raise assent to any laws that have been passed from both houses. The fact that executive is a primary lawmaking just makes sense to prevent any state legislative assemblies to act with themselves in order to prevent the virus from spreading. When they are already in one department, they can act in one order that can have been provided by the executive. That's all from us. Thank you.